Audio exclusive. Bureaucrats behaving badly. Parallel universes and multidimensional roles. One person overlapped and mingled three separate positions to override a legal process. Number one, as EEOD manager. Number two, as consulting attorney to herself. Number three, as deputy legal county counsel representative at hearing board. The bureaucrat hustle, or who needs a dance floor. I entered the hearing board in early fall October morning to reclaim my position, unaware of the legal ambush I was to endure. The following are just some of the inflammatory comments and assertions made by county legal counsel, the chairperson, and hearing board members seated in a supposedly impartial legal process. Misrepresentations made by county legal counsel addressing hearing board. And I need to make sure you understand the fact that the state may have given him disabilities, a matter of law. In other words, it's clear that someone is determined by the state to be disabled does not mean they are disabled for the purposes of the ADA. Please, that's just a part of law. Deposition of county counsel. My attorney question: do you believe it was proper for you to withhold from the board the fact that you were a witness in the case and had made recommendations regarding his employment? Answer: I was not a material witness for this case. You weren't? I was not. So notwithstanding the fact that your underling has given testimony under oath that you gave recommendations as to the separation of his employment, your claim is you were not a material witness? I didn't think it was necessary. Did you advise the board that you were the EOD manager at the time? I don't know if I specifically advised them at that time or not. Do you think you had an obligation to do that? I do not. So when you represented the county as an attorney, you believed that when you're in front of the board, it was proper for you to withhold from them the fact that you were the EOD manager at that time. Improper role of a hearing board chairperson and the utilization of inflammatory language and also leading a witness. The employee has been given a reasonable opportunity to respond and is just saying, you owe me, jumping over the process and saying you owe me a reassignment, end of story. But I think that's the record. Tell me about that. Am I reading this right? County witness. Yes, I feel that's an accurate interpretation. Hearing board member 1, false claim to burden of proof and intimidation. So the burden of proof is the county's, and his testimony was that he recalls calling you at least once and perhaps twice, and so that's the evidence. Now you're under oath now, and if you... Hearing board member number 2, an arbitrary allegations. So how far does the county need to go in order to prompt you to come up to the table and perform your responsibilities in this interaction? More fun facts. Notification to appeal board decision was sent after the fact with no signature or date. Stay tuned for awesome index reference.